In the matter of P. NALLAMMAL versus State by the Inspector of Police, Supreme Court allowed one SLP and dismissed two SLPs. The present appeals arose from a common set of facts and had therefore been heard together and disposed of by this judgment. A.M. Paramasivam was an elected member of Tamil Nadu Legislative Assembly during the period of 16 June 1991 to 9 May 1996. He also served as Minister for Labour Welfare, Government of Tamil Nadu during the period 17 May 1993 to 9 May 1996. On 20 August 1996, the headquarters registered a complaint against him and his wife P. Nallammal alleging acquisition of properties beyond known pecuniary resources which were disproportionate to the extent of 38,72,545 during the check period between 16 June 1991 to 9 May 1996. Supreme Court said we may note that it is not the case of prosecution that second accused instigated the first accused to amass wealth disproportionately or that she is holding the properties benami. No material had been brought on record by prosecution to suggest so. Therefore, the act of abetment, as alleged, is either one of conspiracy or one of intentionally aiding. The properties acquired in the name of second accused during check period were valued at rupees 5,34,179 by the impugned order. The question, therefore, before Supreme Court was whether the second accused was liable for abetment merely by reason of the fact that she was the wife of the first accused and some properties were acquired or purchased in her name. The second accused was the widow of first accused public servant. The assets standing in her name were three immovable properties, two cars, share certificates, and some cash balance in the bank. Pausing here, Supreme Court noted that the trial court had observed that second accused showed interest to purchase the land, that she had given the sale consideration which is proved by witnesses, and therefore her acts fall within the third limb of section 107 of IPC, which is one of intentional aid. Regard being had to fiduciary relationship between the accused, mens rea cannot ipso facto be presumed by the mere fact that some assets stood in the name of second accused and she had extended consideration for the same. The court cannot be oblivious to human realities, especially the usual course of human conduct in marital relationships. Court said that we are cognizant of the presumptions provided for in criminal law, but the same by itself cannot supplant evidence. Court said we reiterate that suspicion, however strong, cannot take the place of evidence. To presume culpability of a close relative of public servant merely on the ground that certain transactions were made in such relative's name would be akin to reversing the burden of proof. This may have dangerous consequences and result in diluting presumption of innocence beyond what the statute in question contemplates. Another striking feature in the case was that during the entire trial, prosecution never took the line of proving that second accused was all along aware that money from which assets were being bought in her name were obtained through ill-gotten or unlawful sources. Thus, under bona fide belief, she has tried to defend the acquisition of assets, trying to explain the sources from various means which cannot lead to presumption in law that she was party ab initio to such illegal acquisitions, as ultimately she is a housewife and from record it can be safely stated that it was the late husband accused who arranged money from which the assets disproportionate to the known sources of income of the family had been bought in her name. Thus, the role of second accused, in the opinion of the Supreme Court, does not fall within three illustrations taken note of by court in P. Nallammal. It is for prosecution to prove its case beyond all reasonable doubt, and a solitary circumstance of name lending, such as the one at present, cannot lead Supreme Court to draw and sustain an inference which unerringly points to guilt of the second accused. There has to be something more in the form of positive evidence to satisfy the essential requirements of offense of abetment. Life and liberty are not things to be trifled with on basis of conjectures and surmises. Court said that presumption of innocence is a basic tenet of criminal jurisprudence and it gets dislodged only by presenting cogent and reliable evidence. Not for nothing it is stated that the accused is the favorite child of law and to him or her inure all the benefits of doubt as available in law. There is absolutely no evidence on record, much less any evidence to satisfy the standard of proof beyond reasonable doubt to establish that second accused conspired or colluded with or intentionally aided the first accused in committing offences under sections 13.2 read with 13.1e of the Act. Therefore, Supreme Court held that the acts of the second accused do not fall within ambit of section 107 of IPC, and in such circumstances it would be unsafe to sustain her conviction with the aid of section 109 of IPC.